Hello everyone, this is Umar Usman. I'm the HR professional, graduated master in human resource management. Today I'm here to bring you or discuss the gratuity. This is the employee right, the worker right, which is secured by the government of Pakistan by passing the law 1972. So today, in my career, I come to know with several people from the worker, from the doctors or the watchmen. People are not aware about their right, and it is secured by the government of Pakistan. And the slides I'm sharing, it is the slide which I learned from in my when I was studying the labor law. One of my mentor, he's owning this firm, HR professional promotion. So we will discuss about this law with the help of this slide. It's a gratuity. Gratuity is actually the term which is come from the gratuity, means with this is a voluntary benefit. Earlier it was given by the employer or the company to their staff without is a benefit for the past service they have done performed with the organization. So as is mentioned, it was in 1972 it became a part of the law of Pakistan, and Standing Order 1968. It was a nice is obligation for the employer to give the employee. So gratuity is become a legal entitlement for the worker, and there are some differences, like if this is a manufacturing organization or the factory. So if they are having more than 19 staff since last 12 months, so they are liable, they are obliged to pay the gratuity to their worker. And if it's a service sector industry establishment with more than 49 staff, so they since last 12 months, if they are having the more than 59 staff, so they are obliged to pay this gratuity to their staff. It is a different payment from the bonus, settlement of award, or any other thing. They cannot bound in this. It's a totally different payment. So gratuity cannot be covered or cannot be says that it has been under the division of any other benefit that they are providing. So it must be clear. If worker die, or in this condition, this is obviously it is their right. In any case, the employer have to pay if they are falling on those conditions which we discussed earlier. So they must pay the gratuity amount to their dependent, nominees, or next of kin. There are different other payments, which is provident fund, gratuity, or pension. But gratuity is an obligation which have to be covered, have to be given apart from the provident fund or pension. Provident fund and pension, they are not covered under the government side obligation. If their employee want to pay, want to give the any one of any or two of or all three these benefits, they can pay, but they cannot undermine the gratuity. Some of the employer, they are giving gratuity and provident fund, some of the employee giving gratuity and pension, some of the employee giving gratuity, provident fund, and the pension as well. But they cannot obsolete the gratuity. They can obsolete pension, they can obsolete a provident fund. So the next it is giving the law does not bar any provident employee if they, yes, the same thing we discussed earlier. So it's up to them, or they can give all three of them, they can give two of them, but gratuity is compulsory if they are following on those conditions which we discussed earlier. So entitlement, there are some conditions who are eligible for this or entitled. First one is if the employee first is if the factory or the employer are coming under this circumstances, they are owning The manufacturing site, at least 20 worker for the last 12 months, or in case of industrial establishment, they are having a minimum 50 staff for preceding last 12 months. So they are under the SO 12 obliques 12 article 6 till sections 12 article 9 is covered under that. Second, worker length of the service the staff or the worker has provided to the employer is they have continuously worked with their employer for last 12 months consecutively without any gap. So if they have performed their services to the employer, so they are eligible for the gratuity. And in case if they are they have exceeded for if they have exceeded 12 month plus 12 month plus ones, which is 1 year 6 months, so they will get 2 gratuity. And if they have completed 2 years, they will get 2 gratuity. If they have completed 2 years 6 months, they will get 3 gratuity. And if they have done 3 years, they will get 3 gratuity. So this is how it does it is goes. 1 year and 1 year 5 months 29 days, they will get even 1 gratuity. They must have to get the 2 gratuity or above, so they must cover the 1 year or the years plus 6 months. So then they will touch the second gratuity. Not less than 6 months, exactly 6 months. For the first gratuity, they must complete the 1 year. Then later on, it goes to the 6 month and completion of the year. If you have any confusion, you can comment on that. I will clarify the thing as well. It should not be the worker cannot if worker must note that both conditions must be satisfied. The third condition is large extent to first condition. So complete out their control, they raise the interesting questions. So we can get this more clarification of the first condition by these examples. Like for example, if after having satisfied all these 3 conditions, for the number of year workman face a situation where the downsizing or restructuring of the establishments goes on, run short of the number of worker required required by the ordinance, as earlier we discussed in the law is mentioned. For the last 12 months, they are having the certain number of staff above than certain number of staff, like 29 and 50 minimum. So if they are shorter than, how does it goes? In that case, the question is whether those are serving. So means it's not you can say not fulfilling the first condition. So then they are not. There is no legal point of view. So the answer is no. They will not get the gratuity if they are under the figure which is required by the law in the first condition. When the gratuity is payable. So there are 5 conditions when we have to pay: the voluntary termination, the resignation from the employee side, when the employee get retired, on the death of the employee, he pass away, so to his next of kin, employee have to pay. On the retrenchment, like downsizing or restructuring is going on in the organization, so when they give the notice to the staff, so then they have to pay that. And the termination, but simpliciter, if there is a disciplinary case, measure has been taken by the employer, and in that case they are on the minor misconduct, they are ending the contract or the employment, so they have to pay gratuity. But in case if it is major dismissal, the gross misconduct, then employer is not liable to pay the gratuity. So it must be clear that what kind of disciplinary measure has been taken. So there are 5 conditions when the gratuity must be paid. rate of payment. So it is always come under the 30 days payment, which is last up to date payment, the last withdrawn salary. So several time I also received the question, the employee hired for example on the 10,000, but currently he is earning after 2 years or 1 year he is earning 15,000. So do we have to pay the gratuity according to the first salary, the when he was hired? So no, it is clear by the law. The latest one we have to pay every completed year of the service means the 6 month. It's different, yeah. It is these two last 2 points we discussed earlier. Here it is the point. The basis for calculation of gratuity: wage dismissed workman is the last month's service, fixed rate salary. This is highest pay salary withdrawn during the last 12 months. It is for the daily wages of staff. This clause is defined. If daily wages they are working for last 12 months, and the piece rate workman they perform, this is the rate we can claim. Yeah, in case employer is not giving the right of to the employee, so employee what is the claim or remedy they can go for this is they can reach to the court, the labor court, and there are clause of section 15 article 2. It define it give you can say secure the right of the employee according to the payment of wages act 1936 for the redress. Yeah, this is brief slides of the definition and the clause, and we have discussed about the thing, who has to pay, what is the condition, eligibility for employer and for employee, and when we have to pay. If you have any question, anything you want to discuss, you can ask me. Always available, but this is just awareness session. I just want to provide. Thank you. Have a nice day. Bye.